Call the next case, please.
Devon, Macpherson versus Metropolitan Government of Nashville and Davidson County.
Mr. Holloman, and we may have to start charging you rent.
I haven't been here in like 7 years because of COVID, and now I'm twice in 2 days. So.
And before you start, and before we start his clock, let me say the Court of Appeals of Tennessee is one court, but the 12 of us are elected from 3 grand divisions, and we're very honored to have with us today Judge John McClarty from Chattanooga, Hamilton County of the eastern section, and we're thankful that he's here. He and his colleagues from the east come to Nashville every year, and we all go to Jackson, and then I will be going to Knoxville next week, I think, to sit with him. So we're thankful to have him with us. Mr. Holloman, the floor is yours.
Okay. Thank you, Your Honor. Jason Holloman here today on behalf of my client, Mr. Devon Macpherson, who is here with us today. I would like to reserve 5 minutes for rebuttal in this argument. Members of the court, this is, as we have seen more and more, a case about regulation of Airbnbs, short-term rentals in Davidson County. I want to jump right in and say we certainly respect the right to regulate these and to regulate these vigorously. I mean, this is a complicated issue for how we balance neighborhood interest with the interest of owners of these facilities to host visitors into our city. My concern and the issue stated in this lawsuit is the way in which the regulation has been framed within the Metro Code. There are 2 Metro ordinances that are read together that create a restriction that I believe is constitutionally impermissible. Metro Code of Laws 17.04060, which limits the use of a house to 4 sleeping rooms. It sets the maximum of 4 sleeping rooms that can be used for an Airbnb. And then that is read together with 17.16.250 subparagraph E4F, which sets a limit of the number of persons in one of these Airbnbs at 2 times the number of sleeping rooms plus 4. That's the quantification. So if you have a maximum 4-person house, you are capped at 12 people. And I will just say to this court, we have no objection to a maximum of 12 people being permitted on one of these properties. I'll get into more detail later, but the idea is that we need to respect our neighbors, and that means noise and just simply volume of people in a facility, parking issues, the number of cars that come with 12 people. We don't object to 12 people. What we object to is the arbitrary 4 sleeping room arrangement that prohibits a 5-bedroom house from being utilized for an Airbnb. And I will say parenthetically to this court, in a lot of cases, typically when you have, there's no acreage requirement set in this ordinance, right? But typically when you have a larger 5-bedroom house, you tend to have more property. You certainly are going to spread people out among that house better. And so the argument that we have here today is that it is that distinction. We would be happy with a 12-person cap on a 5-bedroom, on a 6-bedroom, on an 8-bedroom. We understand that. It is arbitrarily limiting that you can only do this in a 4-bedroom or less house. Now, we've made 3 claims. We've made 2 fundamental right claims. I think very plainly, if we are successful on that, there's been no effort by the city to articulate a compelling state interest in this. There is a Texas case, it's the Zatari case, that I brought up primarily to say we believe that there is a fundamental right of assembly that is in play here. We believe that there is a right of privacy that is at play here. The Zatari case out of Texas.
Let me ask you this
Yes, sir.
question, though. Is there any circumstances that if you have 5 or more bedrooms that you can qualify?
No. That's the issue.
That's it.
And the Texas case, and I'll say, as I'm sure this court is well aware, there's a special relationship between the history of Texas and the history of Tennessee. The language at issue in the Texas Constitution, which is why I brought it up, is verbatim to the Tennessee Constitution. I believe probably lifted by the framers originally. But it says that the right of assembly is enacted under that language. And that language is in both the Tennessee and the Texas Constitution, that citizens have a right in a peaceable manner to assemble together for the common good. And so if that is the case, then we are in strict scrutiny land. And as I said,
Doesn't assembly for the common good really mean assembly for political or religious purposes?
that's not what the Texas court said.
That's what the dictionary says.
Well, I understand.
Black's Law Dictionary.
So, I will say to this court, I thought it was important to bring that up because specifically the Texas court found that they're not going to really dig into the reason in which you're assembling, right? The other issue, though, is a right to privacy, and I actually cited the Griswold v. Connecticut case because you're talking about how people are sleeping in a house. That is, I believe, implicates a fundamental right of privacy. But I want to say to this court...
Are you really talking about how people are sleeping in the house, or are you talking about a limitation on how many people, theoretically, how many people are going to be in a house, in a particular house?
Respectfully, Your Honor, you're not, because it allows the number of sleeping rooms times 2 plus 4. And so it is saying if you take 12 people and you put them 4 to a room in some of those rooms or 3 to a room in some of those rooms, that's okay. But you can't have them in 5 rooms spread out in pairs. That's how this regulation works. And so I do think it is fundamentally regulating the way in which people are required to sleep in that house. And I think that does implicate a fundamental privacy issue. Now, I want to say to this court, I have raised those and I believe in those issues, but in this circumstance, I don't even think that this court has to address those fundamental privacy issues and right of assembly. I respect the comment about the common good. I think that that is a reasonable other way to read this language. The Texas court did find that it was in play. But at a minimum, the Fallon case, which we're all familiar with in a lot of contexts, says that you have to have a rational basis. And what it specifically says is that an ordinance will be invalidated where it has no substantial relation to public health, safety, or welfare. And I just want to keep reiterating that the 12-person maximum, I do think, can relate to public health, safety, and welfare. But the configuration of how people reside in those homes, there has been no articulated basis for that nexus. The reason offered by Metro is preserving residential character. But whether those people sleep 2 to a room in 5 rooms or 3 to a room spread out over 4 rooms has no relationship to protecting residential character. If anything, I would argue to you that having it so that you can sleep 2 to a room probably encourages families, probably encourages couples as opposed to bunk rooms for frat parties. So there's been absolutely no articulated reason for this distinction. A 12-person cap, fine. But distinguishing why a 5-bedroom house can't be eligible for use as an Airbnb with that same cap versus a 4-bedroom house just simply hasn't been articulated by Metro, and I don't think that there can be a reasonable relationship articulated for that distinction.
So the challenge is really on the bedrooms, not the persons residing in the house.
Absolutely, Your Honor. It's on that limit. Like I said, if we keep a 12-person maximum, I think the ordinance would have to be reworked because of the way these two are read together. But if we set it at a 12-person maximum, whether you're in 4 bedrooms or 5 bedrooms or 6 bedrooms, I think you eliminate this conflict and still create a regulation that makes sure that you don't have excessive vehicle parking, a crowd that may tend towards more noise. All of those things can be addressed with the 12-person cap. But right now, you're actually allowing what is most likely a smaller home to have more people than a larger home to be used. And again, this isn't really in the record, but those homes are going to tend to be larger. 5-bedroom homes are going to tend to be larger homes on larger lots, and probably more amenable to protecting the residential character than a 4-bedroom home on a smaller lot. So reserve the balance of my time unless there are other questions.
Thank you.
Thank you.
We'll hear from the appellee. Good morning.
Good morning, and may it please the court, Brooke Heavener for the Metropolitan Government. We are asking the court to uphold the Chancery Court's dismissal of Mr. Macpherson's declaratory judgment action. And we believe that there are 3 different paths that the court can take to get there. Number 1, the court can affirm the Chancery Court on the merits of this case. Number 2, there's justiciability concerns that would require dismissal of the case. And number 3, the case is barred by res judicata. I'm going to begin by discussing why the Chancery Court correctly determined that Metro's short-term rental ordinance is constitutional, and then I'd like to discuss the other 2 issues after that. So the first path that the court can take is that Metro wins on the merits. And let me point out what is at issue here. The injury that was alleged in the petition was a failure to get a permit. And that is just not at all tied to the rights that are invoked, the rights to assembly, the right to privacy. We're here today because Mr. Macpherson wants to rent out an additional bedroom in his home to make money. We're not here because he wants to assemble with people in his home. And absolutely, citizens have a fundamental right to assembly and to redress grievances, but citizens don't have a fundamental right to make money off of their home in any way that they please without regulation. I think that applying the assembly clause here or privacy clause to this statute is overreaching and really goes beyond the breadth of the assembly clause and the right to privacy in the Tennessee Constitution. And I just want to point it back to Mr. Macpherson has not even alleged facts in his petition to show that his individual assembly rights and his individual privacy rights have been implicated. So he doesn't really even have standing to bring those claims. Mr. Macpherson relied on the Zatari case. There's a few things that I think are important to point out about the differences between the ordinance that was at play in Zatari and the ordinance that's at play here. The Zatari case, that ordinance actually did regulate where renters could be in a home at specific times. It said that they had to be in the home during the hours of the night. It said specifically that they couldn't have assemblies. And of note to anyone that lives in Nashville, assemblies in that case, the word assembly included bachelorette parties. But
It's not a bad idea.
but here, Metro's ordinance simply uses it's really the definition of what a short-term rental is that it's a 4-bedroom property that's rented out for less than 30 days. You know, we have short-term rental properties that have more than 4 bedrooms, and those are hotels. And those are residential, or those are not resident in residential areas.
To have a
they're
rational
commercial.
basis, that doesn't mean other options aren't rational too. It doesn't mean that you can't make arguments for other options. It means you picked an option, and that option you picked is rational. Is that not correct?
Yes, Your Honor, that is correct.
So picking 4 rooms as opposed to 5, you don't have to justify why you picked 4 over 5. You just look at 4 and say that's rational, correct?
Yes, Your Honor, that's correct. Yes. The rational basis standard just asks for any conceivable basis. And I think there absolutely is a conceivable basis that limiting to 4 bedrooms would preserve residential character. And in fact, we have other occupancy limits in residential areas for long-term rentals. For example, I believe that it's limited to you can't have more than 3 unrelated people in a long-term rental in a house. So there is a basis for these types of regulations, and there is a rational basis for what the Metropolitan Council did. But again, and I do want to just point out that the right to assembly and the right to privacy just really are not implicated here by the plain language of the petition itself. And the Tennessee Assembly Clause, I haven't found any case law that would support the interpretation that the Assembly Clause would apply to zoning regulations in a local government's code. So that's the first path that the court can take. The court can affirm the Chancery Court based on the merits of this action. The second path that the court could take to dismissal is that this case just isn't justiciable. And there's a few reasons for that. First, as I mentioned before, I think there's a real standing issue here because, again, the injury in the petition is failure to get a permit. There's a couple problems with that. Number one, Mr. Macpherson did have a permit at the time that the petition was filed, so that just wasn't an actual injury. And number two, again, it's not his assembly rights at play, it's not his privacy rights at play. When you are asking for a declaration that something's unconstitutional, it has to be your individual rights that you're asserting. You can't assert on behalf of someone else. Second, there's a ripeness issue here. This is basically just a petition based on hypothetical facts. Mr. Macpherson said that he was denied a permit, but in reality, his denial is based on an informal email exchange with a Metro employee. The date that he was emailing with Metro about, could I get this permit, he was actually barred by a court order from having a permit at that time. And that was based on an environmental court case. So Metro legally could not have issued a permit at that time, and because of that, I think that makes this not ripe for review. There was an independent basis beyond the bedroom issue for a denial of that request. And additionally, just generally, whenever we have cases dealing with permit denials, the correct vehicle for bringing that type of case is to get a formal denial, to appeal to a board, create a record, and appeal through a writ of certiorari. And there's a reason for that, because a writ of certiorari under the state legislature has created specific timelines for when you can file those. You have a 60-day limit. It allows the government to create final decisions easily and quickly. And here, Mr. Macpherson emailed in 2020 and filed a petition 2 years later. And if you think about the numerous, Metro issues hundreds, if not thousands of permits per year, if every single informal email exchange could open the gates to a declaratory judgment action, it would really hinder the efficient operation of the government. So that's the path to dismissal number 2. And the third path to dismissal is that res judicata bars this claim. Mr. Macpherson has been permanently enjoined from violating the code provision that he's now challenging. And he was enjoined for that based on an environmental court enforcement action. I want to point the court to Taylor versus Greene County that we cited to in our briefing. In that case, and it is a memorandum opinion, but I found that the facts were extremely similar to these facts. A citizen was enjoined faced injunctive relief because they needed to tear down a garage that violated the zoning code. And instead of asserting an affirmative defense that the zoning code was unconstitutional, they lost under the injunction and then filed a deck action challenging the ordinance. And this court found in that case that that was absolutely res judicata. Mr. Macpherson, in his briefing, has challenged 3 of the res judicata elements. That the first being that that the lower court's injunction was not a court of competent jurisdiction. But the environmental court might not have had the ability to issue a declaration of rights, but absolutely the environmental court had the authority to look at whether or not an ordinance that it is enforcing is constitutional. And Mr. Macpherson had an obligation to bring up that issue in the environmental court action and the subsequent circuit court appeal. And in fact, he did bring these issues up in the circuit appeal. These issues were briefed in the circuit appeal, and Mr. Macpherson abandoned his appeal. The prior judgment was final and on the merits. The circuit court case, his appeal to circuit court from environmental court, was dismissed based on an agreed dismissal. And in Gerber versus Holcomb, this court found that a agreed judgment of dismissal is conclusive not only on the matters actually raised, but also on every other matter that could have been raised. These constitutional issues could have and should have been raised in the former action. And finally, if you look at whether or not this is the same cause of action, this is related to the same property that was at issue in the environmental court case. It's related to the same type of permit. This is absolutely the same transaction under the transactional test. So because Metro wins on the merits of this case, because this case is not justiciable, and because this case is barred by res judicata, we are asking that the court affirm the Chancery Court's dismissal.
All right, thank you.
Thank you.
Mr. Holloman?
Thank you, members of the court. I'll briefly touch on some of the other issues that were raised. The trial court found in favor of my client as to the res judicata issue. The issue that had happened previously was an environmental court action. I will say it's a little beyond this record, but it related to residency requirements, which ultimately Mr. Macpherson prevailed and demonstrated he was a resident of this property. And there was an issue about advertising of 5 bedrooms, which is sort of what led him to then bring this subsequent action. There's a difference between advertising for something beyond your permit and whether or not you have a constitutional entitlement to that. And we filed a declaratory judgment action for the very reason that we believe that these, as applied, are unconstitutional. And we have a right to do that in the format of a declaratory judgment action. And so that was the format that was taken. The trial court agreed with us on that issue. As a brief aside, I'll say also that you have to have a court of record for res judicata to apply. These actions that were referenced by Metro Legal occurred in environmental court, which is actually a subset of the Metro General Sessions Court. It's not a court of record. So for that, all those reasons, the trial court did not find that res judicata was appropriate in this matter. Let us proceed on the substantive issue, which is what we're here appealing on.
What about, can he raise these constitutional issues when those issues actually belong to the renter?
Well, I think certainly as to the rational basis, right? Because that's his permit. I think as to the assembly issue, I understand those, and there's some of the discussion of that in the Zatari court as to whether or not he could do that. They determined that he could, but I think that's a fair point as to the assembly issue. Is it the assembly of the owner? Is it the assembly of the patrons? But as to the rational basis question, that's a permanent issue. Can he obtain this permit for use of his home for rental of 5 units versus 4 units? And so with that, I think he absolutely can. And I want to come back to the rational basis because I really do believe, I think those fundamental rights are worth discussing. Obviously, that's why I put them in the brief. But I'll concede, those are complicated arguments and bring on a lot of other policy issues. But the rational basis question here is and I heard what Your Honor said earlier, fair point as to can we set a maximum of 4 bedrooms. And where I would say to that is, but where we have said very plainly, it's okay to have 12 people in this house, where the government has set that policy, I think that there is an obligation to establish a rational basis between that nexus of 4 sleeping rooms and a 12-person maximum. And I don't think the city has articulated, and I don't think the city can articulate a reason for allowing 12 people, but limiting them to sleeping in 4 rooms versus 5. That's the lack of rational basis in the regulation. And that's really what we're here today to say. We're fine with the 12-person maximum, but whether they're in 4 bedrooms or 5 bedrooms or even 6 bedrooms is really not the business of the city. And that's where I think the regulation fails to articulate a rational basis. And the only, we also have to look at what's the rational basis that's been stated. And it is to preserve the residential character of the neighborhood. And so, if we go back to the Fallon case, we have to say, how does limiting to 4 sleeping rooms versus 5 sleeping rooms preserve the residential character of the neighborhood? And I don't find any way in which that occurs. In fact, like I said, I think that there's a good argument to be made that you're forcing sort of dorm, bunkhouse type living when you limit it to 4 bedrooms, and that is antithetical to the residential character of a neighborhood. So, with that, if there are other questions, I'm certainly happy to answer those. Okay.
Hearing none.
Thank you, members of the
Thank you,
court.
Mr. Holloman and Ms. Heavener. Thank you for your arguments. We'll take this matter under advisement. Please call the next case.